Good morning. Let's talk about some types of law. In the United States, we have a federal system so that there's federal and state law. And it can get a little complicated whose law controls in any particular situation. The number one place source for law is the Constitution. We have both a national constitution, and every state or commonwealth has their own constitution, and that's considered the supreme law. So all other law must obey that one. So any statute or any court decision that contravenes constitutional law falls on the constitutional law stance. This was decided in 1803 in a case called Marbury versus Madison, where they established something called judicial review, and that is the power of the court to decide in their own wisdom if an act of the legislative or executive branch is constitutional. That's an enormous power. One of the three branches, the judicial branch, has taken it on themselves to be the arbiter of what is or is not constitutional on the actions of the other two branches. It's hard for me to emphasize enough how much power that gives the court. Below constitutional law is statutory law. So statutory law is higher than all other laws except for constitutional law. And again, statutory law, that's what the legislative branch does. And we have a federal bicameral system, that is the House of Representatives and the Senate. And then every state has a system, whatever it is that they've decided. Here in Colorado, we also have a bicameral or two-house system of legislation. In terms of how statutory law impacts business, it can be enormously complex because different states pass different laws. And so if you are making a product, let's say in Colorado, and selling it to citizens in Washington, you will have to make sure that you're obeying both laws. A very particular state in that regard is California, which in often cases have laws that are very different than the other states. So you see that in tire manufacturing is one place where California really stands out. Below that is administrative law. And this is really where most laws are. So if you kind of think of an example, the Congress will pass a law that says we need greater scrutiny of immigrants from Syria because we're afraid of terrorists. So that doesn't really tell us what to do, right? That will go to an administrative branch. In this case, it's immigration and naturalization. These administrative branches act under the president, under the executive branch, so they are enforcing the laws. And they're going to fill in all those details. So they're going to decide what kind of background check is required, and is fingerprinting required, and how many references they're going to need to get to say that they're a good person. And all those details are filled in by this administrative branch. They don't actually pass laws. They don't have that authority. That authority rests with the legislative branch, with statutes. They promulgate rules, but those rules are probably going to be more impactful for you in your daily life than anything that Congress or the courts do. And then finally is common law. This is, the United States is a common law state. That is to say that we are a state that derives its power from judge-made rule. This was created before the United States was even conceived of. It's a British theory where cases that would come before a judge that had never been decided before and for which there were no laws around, the judge would just make something up. And it is the foundation of our U.S. legal system. So whenever anyone complains about an activist judge, that is a judge making laws from the bench, the response is that's the system that we've chosen as a nation. So the very first case that we have in Britain of common law is kind of a fun case. There was one owner had a cow in the field next to it. The other owner had a bull. The bull broke the fence between the two farms and impregnated the cow. And the two farmers went to the court, and the question was, who owns the calf and who has to fix the fence? And in that case, the judge decided that the owner of the bull had to fix the fence because it was the bull who broke the fence, and the owner of the cow gets the calf because the owner of the cow had to have all of the risks associated with his cow being pregnant. So that is classic common law, and that is still precedent today in the United States. That case came from the 1500s. Now, what's important is judges at the trial level never make law. They're making decisions based on facts and based on the law that already exists. It is when you appeal a case that those additional things happen. Ooh, I went backwards, didn't I? Stare decisis is a fancy legal word for let the decision stand. If you are planning on going into business, I'm happy for you to call it precedent. If you think you're going to law school, then you might as well learn the term stare decisis. And what this means is once a court has made a decision, future courts should make the same decision, and that creates reliability. So in the case we just talked about with the cow and the bull, the next time someone comes with similar circumstances, one owner's bull impregnates another owner's cow, the owner of the cow gets the calf, even if no fence is broken. So that principle also came to us from England, and it's supposed to allow consistency and reliability. When people are referring to activist courts, I kind of think that they're conflating both the fact that judges can make law, which is true in a common law system, and they're conflating that with this idea of stare decisis. In other words, that the courts, or what they're actually doing, is changing existing laws. And there have been courts, notably Supreme Courts, who have changed existing laws. The Warren Court, so named because of the Chief Justice Warren from the 60s and 70s, was an activist court changing existing law. In other words, ignoring stare decisis and making new laws in a very liberal manner. That's the court that gave us Roe versus Wade, the decision that gave women the right to terminate pregnancy. And that's the court that ended miscegenation, that is, the practice of denying African Americans the right to marry other non-African Americans. Today's court, the Roberts Court, again named after the Chief Justice, is also an activist court, a court that has no problem ignoring stare decisis and creating new laws in a conservative way. And a couple of their famous cases is the Second Amendment, which essentially eradicated the militia clause of the Second Amendment and gave individuals the right to bear arms irrespective of that language in the Second Amendment. And the Citizens United case, which deemed that a corporation was a person for the purposes of raising money in a political campaign, and said that there can be no limits on how much money an individual, including a corporation, could give to a campaign. So those are some examples on both ends of the political spectrum. And that's it for common law. Or, excuse me, that's it for types of law.